Today we will be talking about the third and final branch of government. We do have two more lectures on policy, domestic and foreign, but this will be the last of the three branches of government. It will be the judicial branch. So today we are going to talk about how the law reflects the American people and our national culture. We'll talk about the judicial system itself, the court's role in American politics, and then we're going to talk about the inner workings of the Supreme Court. So, just so you get an idea of how the Supreme Court actually looks at their cases, how they decide which cases they're going to do. And then we're going to talk about 19 landmark cases. These are blockbuster cases where the Supreme Court ruled a certain way and it affected many things. So your text has picked out these 19. There's lots of court cases that are important that the Supreme Court has ruled on, but they've picked these 19 just to kind of show you how the courts, how much power they have, how they change their mind sometimes, not necessarily the same people, but maybe 100 years later, a new Supreme Court might think a different way on something. So you'll see some bad rulings and then some good rulings, and we just never know which way they're going to decide. And then we'll also, so those 19 cases will be what I will draw one of the essay questions on your final. So please pay attention to those. I'll discuss how that will happen. There's a little bit of intricacy. You'll have to figure out what your last name begins with and which cases you'll be writing about. And then we'll talk a little bit about how the court could be reformed, and intermittently I will talk about the Nevada courts. So let's get right to it. Basically, our trusting courts, traditionally lawyers and courts, used to enjoy a very high prestige. Today, approval ratings are waning, which means they're dropping for the courts. You often have a lower approval rating for courts and lawyers than we did in the past, especially with controversial decisions and cases like Bush v. Gore, which we'll get to later and is in your book to read more about. So if you look at law and lawsuits, we are a country of litigation. And litigation is the conduct of a lawsuit. So it's in bold. You should know what litigation is. It's a conduct of a lawsuit. Mediation is another way to solve a problem. This is deciding on disputes without going to court and using a third party to help negotiate a settlement. Many other nations rely on mediation. This is having a third party listen to both sides and say, why don't we do this? And then we save the court costs, we save your lawyer fees, we save all the problems. But unfortunately, Americans sue on a higher rate than other countries. If you look at the charts, this kind of shows you per capita, which means if you divide it by the population of the country. In Japan, there's close to 6,000 lawyers. I'm sorry, to one lawyer, there's close to 6,000 people. In the United States, we have one lawyer shares with close to 300 people. So you can see that we have a lot more lawyers per capita, per person, at our disposal than a lot of the other countries, or at least specifically to Japan and some of these other countries. So organizing the judicial branch, as we have with the executive branch and the legislative branch, we go back to the Constitution in the first couple courses. What does it say in the Constitution about the judicial branch? Not very much. It's a very short article, Article 3. That was the article that many of you contacted me to tell me that we had wrong on the first exam. So yes, I'm glad that those of you who've realized, wait a minute, I know the judicial branch is talked about in Article 3. It's a very short article, And it basically just says the power, judicial power is vested in the Supreme Court, but it doesn't give us any instructions on how big the Supreme Court should be, how often it should meet. It doesn't even talk about lower courts, but it does give Congress the power to design the rest of the federal court system. So we're going to learn about that court system that Congress has created through our history. This is the best chart to kind of get an idea. This side are our state courts, and this side are our federal courts. So usually someone will start a trial or an issue or in a state court. If they don't like the ruling, you can appeal. You would go to a state appeals court. If you don't like that, you can go to the highest court in the state, which is usually called the Supreme Court. We have a Nevada Supreme Court. And if you don't like that, you can appeal to a federal court if it's something that a federal court would look at. If it's a state law or something like that, you might not be able to. And then you could also appeal to the Supreme Court. Now, if it's a federal law and it's not going to go through any of the state courts, it'll start in a district court. And if one of the parties doesn't like the ruling, they can appeal it to the Court of Appeals. If one of the parties doesn't like the ruling there, they can try to get the Supreme Court to look at it. Same thing on this side. You can try to get the Supreme Court to look at it. The Supreme Court is approached by thousands and thousands of cases, but they're only able to look at a small amount. So we will look at how they go about the process of deciding which cases to look at in a little bit. All right, so federal courts look at court cases that are crimes that violate federal laws, or issues that involve federal treaties, or a constitutional case, a U.S. constitutional case, or maybe a dispute amongst state lines. So district courts, like I said on that map, is the first level of the federal court. The judges are appointed by the president and are subject to approval by the Senate. They keep the office for life. So federal judges are appointed and they keep their office for life, so that for lifetime. So that means district court judges, appellate court judges, which, by the way, appellate courts are also the same as the circuit courts. So if we go back to here, you can see they're called Court of Appeals, or these are also circuit courts. All of these judges are appointed by the president, approved by the Senate, and have their job for life. They can move up and get a better position once they're in the Supreme Court. There's nowhere else really to go at this point in time. And then these, depending on the state, are either appointed by a governor or voted into office, elected. I'll talk about that in a minute. All right. So state and local courts are where most of your trials start. 90% of all non-traffic cases are handled in state and local courts. They're the first stop for most of the cases, and appeals are handled by the state appellate courts. So this is kind of reiterating that graph we just looked at. In high-profile cases, appeals from state courts may be heard by the Supreme Court. Depends on what the topic is. Unfortunately for state judicial selection, so deciding on judges, there are few formal criteria for judicial selection. And depending on the state, you may not even need a law degree. That means you may not even need to be a lawyer to become a judge. 22 states require no formal training. That's scary. I could see small town judgeships. Maybe there's nobody qualified, but that would be scary. Most judges first make their names as lawyers. 17 states authorize their governor to select the judges. 2 states leave the selection to the legislature, so that means they have their state assembly or state senate vote for the judges. And 31 states elect their judges, including Nevada. And their terms vary, and it's usually renewable. You need to know that. We elect our judges. Any of you who have voted in the past will know that there are judgeships that you vote for. So we elect our judges for 6-year terms. It's in bold. You need to know that for the exam. They often run unopposed. If you have voted, you will see that there's nobody running against them. You must be 25 years of age, a registered voter, a resident for 2 years, and a licensed and practicing law for 15 years. So when I have a face-to-face class, I like to look at everyone's face and see if they're paying attention and they've really read this slide, because what would that mean? That if you've practiced law for 15 years and you're only 25 years old, the legal age to run for a judge, that means you got your law degree when you were 10. So most people are not 25 years of age that run for judge, probably closer to 40. All right. So electing judges is very controversial. If you think about it, it makes sense why electing judges is controversial. Because, maybe people are giving them campaign contributions. They have to make promises to people. It could lead to bias or corruption once they're a judge. Maybe they have to favor. And studies have been shown that campaign contributions, the biggest group of people that contribute to judges' campaigns in states are lawyers. So just think, lawyers end up seeing the judge when they're trying to win a case, and they might say, hey, remember I gave you some money a little while back for your campaign, or hey, I'll be giving you some more money for your next campaign. Why don't you rule in favor of what I want? So that's the problem. The flip side of it is that, many states still insist that judges are accountable to the people, and that if they're not judging properly, they'll get voted out of office and we get to choose them. So depending on how you feel about whether judges should be elected or selected, but what you do need to know is that judges are, where are we? They are elected for 6-year terms, not selected by the governor. Okay, so in one of my last lectures, I had a problem with my with recording the lecture, and I played a little bit too long a period of John Oliver, and YouTube told me I couldn't post that. So I had to cut it out of my last video. This is a very long video. It's 18 minutes. I'm not going to play it for you because I don't want it to signal a flag on YouTube. But I would highly recommend that you watch it. It's funny and interesting, and kind of, it's about states that elect their judges and how that could be a little bit corrupt. So please watch that in your spare time. All right, so federal courts, like we said, deserves to be repeated so you can remember. They look at 3 kinds of cases: cases that violate federal laws, issues that involve federal treaties, and cases that touch on the Constitution. That's in bold. You should remember that. Also, federal cases begin in one of the 94 district courts. You need to know that there are 94 district courts. So there's one in each state, and some states that have larger populations have more than one. And in order to run these courts, we have about 700 judges in the district court level. And then above the 94 are the 13 federal appellate courts, also known as circuit courts. And then just interesting to know that about 1/3 of judges are women and nearly 3/4 are white. And that's not changing with this administration. This administration is quickly appointing more and more federal judges. There's a lot of vacant positions that they'll be appointing or trying to. There's a couple. Yes. There's a recent John Oliver that exposes some people that have no experience recently that have gone up for hearings with with Congress before being approved, and even Republicans questioning them, you can see on their face that they had no experience. And so it's also a scary way to pick judges, because there's no rules that says that the president has to pick judges that have a good track record or even know what they're doing. All right, so district courts, I think I just said this, yes. Every state has at least one district court, and larger states have as many as 4. So in the district courts, they will hear the case. It will be like a regular trial. They determine the facts of the case. They build a record detailing the evidence. They apply the law to reach a ruling. And in this case, the cases are heard by a single district judge. Then, if it gets appealed and it goes to an appellate court, 3 circuit court judges will hear this case, and they will determine whether the ruling is correct or not. So basically, the appellate courts are a check on the district courts. So they're basically hearing the whole thing again, exactly the way it is. So they look at the record. They don't have a new jury. They don't have a cross-examination. They don't present the evidence again. They just read the court records. And then they basically say, yes, we agree with the lower courts, or no, we disagree, and this is why. This is the map of the circuit courts, how it's broken down. So we're in the 9th Circuit Court with all of the western states. So I believe that court's in San Francisco. So if you ever had a federal case that you brought to appeals court, you would go to the 9th Circuit Court. Let's see. In addition to those 2 levels, we also have some specialized courts: military, justices, tax disputes, terrorism, bankruptcy. So we all have some other specialized courts that I'll show you a map of in a minute. Actually, I'll just show it to you now. This map. So you have intermixed with our levels, our district courts and our appellate courts. You also have bankruptcy courts, and then on the lower level you have tax courts, IRS appeals court. So some of them have the military has an appeals level, but these cases can also feed into the federal system and eventually end up in the Supreme Court. And then one more note here on the diversity of the federal judiciary system. Like I said, 1/3 of the judges are women, 3/4 are white, 12% African American, nearly 10% Hispanic, 3% Asian, 1 federal judge is a Native American. All right, so just to look at that again, just so you understand the flow chart of the court cases. Okay, as far as Nevada state courts, we have trial courts that are divided into 9 judicial districts. So when you go to vote next year, you will probably be voting for whatever judicial district you're in. You might vote for a justice of a peace or some municipal court judges. We had no appellate courts until 2014, so until just recently. Now we have 3 judges, and we've always had a Nevada Supreme Court. So our flow chart looks a little bit like this. A court case might start in the justice municipal courts. It could go to a federal court, possibly a federal district court, and then to the Nevada Supreme Court. It could also now go to a court of appeals, but it appears that Nevada's Supreme Court has handled all of the appeal cases so far, so they possibly will look at a case and decide whether they think it should just go to the Court of Appeals or whether they want to look at it. So there's a little bit of movement there. Okay, so what does the court do? So if we were in class, at the beginning of every class, I would probably ask you, what does the legislative branch do? And hopefully you would respond, the legislative branch makes laws. What does the executive branch do? The executive branch implements the laws. What does the judicial branch do? The judicial branch interprets the laws or decides whether something is constitutional or not, or whether it's lawful or not. But this was not necessarily the case because it was never really written in the Constitution that that's what the courts did, even though we just think that that's what they do. But there was one important court case early on called Marbury versus Madison that in the decision that the court made, they basically said, sorry, we can't make a decision on this because the Constitution doesn't give us the right to interpret the Constitution or interpret whether something is lawful. So we can't decide on it. But because they decided on it like that, they gave themselves what's called judicial review. They gave themselves the power because of the precedent of this court case, because of the decision of this court case. They would always look back to this court case and say, we have the power to interpret the law, because they looked at the Constitution for this case and they said nowhere in the Constitution does it say that we're supposed to look at Congress and decide whether something is lawful or not. That might not make sense now, but we're going to watch something that will hopefully explain it better than I could. But there's a whole story behind what this case is about, but in the end, it establishes judicial review. And judicial review is allowing the Supreme Court to overrule an act of Congress that violates the Constitution. So it gives them their role that we know that they have today. So basically, they gave themselves more power. So we'll look at that. Your book talks about activism versus restraint. I'm not going to test you on it, but it's a way of looking at a judge, whether a judge using restraint may say, we're not going to rule on this because it's not our place, or an activist judge, yeah, we are going to rule on it, which might change the decisions that the executive branch or the legislative branch have made. So usually what happens is a conservative might say of themselves, we're using judicial restraint, and may look to liberal judges and say they're using judicial activism, which they shouldn't be, or the other way around, a liberal judge. So it's really usually a judge will talk about another judge using judicial activism as a criticism, and that if they're talking about themselves, that they use restraints. So your book talks about this further if you'd like to look into it. But for now, we're going to watch, I've given you 3 different explanations, but we'll watch the one that appears to be the most understandable. The other 2 you can watch in your own time.
Supreme Court Briefs. The District of Columbia, March 2nd, 1801. President John Adams just has a couple of days left in office, but he's been pretty busy making last-minute appointments for his Federalist friends to important positions. It's basically a mad rush to get them in before the new president, his arch-enemy Thomas Jefferson, takes over. He nominates 23 justices of the peace, basically judges in lower courts, in Washington County. One of those nominated was a dude named William Marbury. Like Adams, Marbury was a Federalist who talked a lot of trash about Jefferson when he ran against Adams before the election of 1800. Even though Adams nominated Marbury and the other 22 folks, and even though the Senate approved their nomination on March 3rd, and even though later that day Adams signed the commissions, which were basically the final order so they could get to work, several of them didn't get the job. Wait, what? Why? Well, John Marshall, the acting Secretary of State for President Adams, did not deliver those commissions on time. Hey, speaking of little John, my friend Jack Rackham, well, hello, made a video about him over on his channel. Be sure to check out his video when you're done watching this one. Okay, back to the story. At noon the next day, March 4th, Thomas Jefferson officially took over as president. He instructed his Secretary of State, James Madison, to only deliver those commissions to some of the nominees. You know, the ones he liked. One of the people who never got his commission was William Marbury. Yeah, Jefferson didn't like him. Marbury was like, that's messed up, man. I was promised that job. He wanted to force Madison to deliver that commission, so he petitioned the Supreme Court to hear the case, and the court actually said, sure, let's do this. They heard arguments on February 11th, 1803. Oh, guess what? By this time, John Marshall was Chief Justice of the Supreme Court. Wait a second, isn't that a conflict of interest? Shouldn't Marshall recuse himself from making a decision for the Nah, Now, 4 of the 6 justices on the court discussed 3 big questions for this case. Number 1, should Marbury and the other justice of the peace nominees get the jobs they were promised? Number 2, can they even sue in court to get their jobs? Number 3, hold up, does the Supreme Court even have the authority to say they could have their jobs? The court announced their decision on February 24th, 1803. All 4 sided with Marbury. They thought Marbury deserved that position and thought, yeah, he should be able to sue to get it. However, hold up, Madison kind of won too, because the law that enabled Marbury to sue to begin with, the Judiciary Act of 1789, was actually unconstitutional because it gave the Supreme Court more power than the Constitution allowed. Wait, so the Supreme Court decided to weaken their own power? Huh? Well, not exactly. You see, John Marshall knew what he was doing. He pretty much did this. He had the long term in mind, baby. While the court gave up power by declaring the Judiciary Act unconstitutional, they also gave the court a far greater power. The power of judicial review, meaning they could call out laws if they went against the Constitution. So if the court could declare the Judiciary Act unconstitutional, they could declare any law Congress passed unconstitutional. You see, Lil John and the rest of the courts had made the Supreme Court kind of a big deal. Dare I say, this was the most important Supreme Court case in American history.
All right. So, hopefully that made sense. If it didn't, I would watch that one again, read about it in your book, maybe watch these 2 to reinforce it, but you need to know what Marbury versus Madison is about. It sets up the power of the court system. So they kind of just gave themselves their own power. Now, what happened with that is that this is a chart of the last 100 years. And these are labeled Warren Court, Burger Court, Rehnquist, Roberts. This is the current court. So this is the name of the Chief Justice. So as long as this Chief Justice was in power, this is the average acts of Congress that they nullified per year. So as you can see, early 1900s, I'm sorry, not 1900s, early 2000s, and the last court nullified the most. So this is how many times they actually changed the law. Because that, remember, that's not the job of the court wasn't to make laws or change them. They were just to find out whether they were lawful or not. But in their decision making, they are changing the law, which is what Congress is supposed to do. So, what could Congress do if a court decides on something that's against what their law that they intended? They could make a new law, or they could make an amendment, or they could, just as long as it's not, it's not unconstitutional. But they could work around it by passing new laws if the court got a little bit too heavy-handed in a more activist court where they were making decisions that were actually changing laws and kind of creating new ones. Okay, so here's some terms that your book talks about. You should be familiar with them. Most of you probably have if you've watched any Law and Order, any kind of court dramas, which there's a million on TV. Common law is the system of law developed by judges in deciding cases. So if they decide a case, then that becomes the law in the sense that you usually look back at that case. A previous court has, especially the Supreme Court, has decided something. It becomes a precedent. Not president, but precedent. This means that it's a judicial decision that offers a guide to similar cases. So in the future, if there's a similar case, they would look back at this precedent. So you did have on your first exam the question about Brown v. Board of Education. And I wanted you to tell me what precedent did it overturn. So we'll talk about Plessy v. Ferguson in a moment. That was the case that the precedent in Plessy v. Ferguson, they basically said that separate was equal. And in Brown v. Board of Education, many, many years later, they said, nuh-uh, not anymore. That's overturned. All right, civil law are cases that involve disputes between two parties, and criminal law are cases in which someone is charged with breaking the law. So criminal law is a person and the law, which is kind of a person against the government. The plaintiff, if you remember, this is the person making the complaint. Plaintiff is the party who brings the action of the lawsuit, and the defendant is the party that's being sued in court. So, does the court have too much power? They are actually shaping a lot of issues as we know it right now, or as we speak. Although I'm doing these lectures a couple weeks ahead of you watching them, but policies, courts are making, the Supreme Court will make decisions on immigration. They'll make decisions on voting issues. They'll be making decisions on abortion. Any of these cases that are coming to the Supreme Court on sexual identity as opposed to sex, whether our sexual identity is protected under the Constitution, and if there's a difference between sexual identity and sex. So that gives them a lot of power. The other, this quote here is that Alexander Hamilton, I love that show. Anyway, that Alexander Hamilton thought that the court, the judicial branch, would be the least dangerous branch. But we're not sure if that's still the case because they have a lot more power than they had originally intended. Even though they don't have an electoral base, they don't have anyone electing them. They have very limited resources, and they rely on the other branches to enforce their decisions. So there's no court police. Once they pass a judgment, there's nobody that goes around and makes sure that everybody follows their decision. For example, in Brown v. Board of Education, many of you commented, as it said in your book, that schools did not desegregate for the first 10 years. There was only 1% of the nation's schools that tried to desegregate after Brown v. Board of Education. So what had to happen 14 years later was they passed the Civil Rights Act in Congress, which became law that said, no, you will not be given any funds if you do not desegregate your schools. So courts don't have policing powers or enforcement powers. So, as far as the Supreme Court, how do they decide on their cases? There's a couple different procedures, and please listen carefully and read your book carefully. Before we talk about the procedures, let's just talk about their schedule. So they're in session for 9 months each year. So they just started in October. They'll go all the way through the spring, and they will listen to court cases a couple days a week. And the rest of the time, they're going to be doing one activity. If you want to be a Supreme Court judge, you better like to read, because they'll be reading all their amicus briefs, which should be in bold, because this you need to know for your exam also what an amicus brief is, or an amicus curiae. It's a brief that is submitted by a person or an interest group who is not a direct party to the case. So for example, if they're ruling on an environmental issue against fossil fuel industry, you probably would have big oil interest groups that will present their side of the case to try to persuade the judges to rule in their favor. And then you would have all your environmental interest groups. They would try to present their reasoning why the court should rule in their favor. So they read these, plus all the court rulings they'll be reading as well. And then in early summer, they start deciding on all the cases. So they listen to the court case early on in the year, in October, in the fall, and in the spring, but they don't give their decision for a while. So they're not making their decisions right there. There's 9 of them. They have a lot to read. They discuss, they get more information, and then they all come together and have a vote early in the summer. Okay, so that's the schedule of it. But how they select the cases, they have a couple of formal requirements. The first one is called the Rule of Four. As you can see, it's in bold, so that means you will need to know this. This is a requirement that at least 4 of the 9 Supreme Court justices, you should know there are 9 Supreme Court justices at this point in time. It hasn't always been 9, as you saw from that video. There was 4 originally. But 4 of the 9 judges must agree to hear a case. So what usually happens is, just imagine a big wheelbarrow full of one-page summaries, and each judge gets to go through the same wheelbarrow, and they go one page at a time, one page at a time. Yes, I'll hear this case. No, I won't hear it. And they make 2 piles. And then it goes to the next judge, and their staff members keep track of which ones they've each decided on. And out of the 9 piles of the ones that each judge thinks they should look at, if there's 4 judges or more that agree on something, then that goes in the pile that they narrow down to. So maybe it narrows down to a couple hundred or something like that. Once they decide which cases, they will write a writ of certiorari, which asks the lower courts to send them all the records. And then before that, they must have 3 conditions. And this is usually done by the staff. The judges don't have to do this because the staff can narrow it down. And the 3 conditions are these: it has to have legitimate controversy, standing, and not moot. So let's go to this slide. So legitimate controversy means there has to actually be 2 parties that are in dispute. It can't be someone just bringing a court case saying, I think we should all do this. If they're not fighting against someone, they have to have a legitimate controversy. There has to be standing, which means that there's some actual harm received. And so they can't just make up something that there isn't a problem about. And then the case has to be not moot. If it is moot, it means that it doesn't really matter what the court decides, because the decision will, for example, if during the time the case has approached the Supreme Court and it was about a person and that person died during that time, then it doesn't really matter what the decision is. Or if they were disputing, this is a better case, if they were disputing a law that they think that Congress should pass or that was illegal, but then during the time that they were waiting, Congress already passed the law, then there's no reason for the court to spend their time ruling on this because it's already been taken care of. Does that make sense? So not moot. So if you don't understand what moot means, it just means that it's not effective. Okay, so then in addition to those 3 formal conditions, there's also 3 informal factors that will help the Supreme Court justices decide whether they're going to hear a case or not. And the first one is that the Supreme Court is more inclined to hear a case when 2 lower courts, like the Federal District Court and the Appellate Court, decided on them differently. So say you go to the District Court. Let me just go back here to our slide here. The District Court rules one way, and then they appeal it, and they go to the Federal Appeals Court. These are all federal judges, and they appeal a different way. Then the Supreme Court's going to look at that and say, why didn't both courts rule the same way? There must be a problem here. We're going to look at that. Oops, sorry, where are we here? So that's the first informal. The second one would be they're more inclined to look at cases where the lower courts made a ruling that's in conflict with what a Supreme Court has already ruled on, a precedent that they've already ruled on. So for example, if a lower court ruled that it was okay for a state to ban abortions in the whole state, but Roe v. Wade said that they couldn't, then the Supreme Court would look at that again. Now, this current Supreme Court, that may happen, and they may overturn Roe v. Wade. We'll see. And then the last informal factor is finding out whether a case has significance, not just for the two parties that are involved, but way beyond that. So in 2015, the court case that was hearing the case on same-sex marriage, the Supreme Court wasn't ruling for that couple only. They were ruling for all same-sex couples in every state, and whether it was discriminatory to withhold certain rights from same-sex couples. So that's something. If it's an issue, that's not just about the people that are bringing the court case to them, but also to other people like them, then the Supreme Court will look to rule on something like that. So just keep in mind, you have informal conditions that they have to meet. There has to be a rule of four. There has to be four out of 9 Supreme Court justices that agree that they're going to look at it. And then they're also, this usually helps them pick their cases. Okay, so once they pick their cases, then I'm not sure if I put this in there, but you can read about it in your book, and I'll tell you now. When they start hearing the cases, they actually, let me just make sure I didn't, nope, I must have taken it out. They actually allow the each side just 30 minutes in front of the Supreme Court to make their case. So the majority of the material to try to persuade those 9 judges is already written in the lower 2 cases, court cases that they've, 2 or 3 if they've gone several, and also in those amicus briefs, those amicus curiae briefs, the friends of the court reports. And then 1 lawyer from each side, sometimes 2 or 3, they'll say 10 minutes each. They have a clock and they have a red light, and they're only allowed to talk for a total of 30 minutes each side. And sometimes the judges interrupt them and take up their time, but that's it. Then the Supreme Court justices have to make their decision. They write their decision in what's called an opinion. They take a vote first, obviously. So if there's 9 of them, they can do that really quickly. Like, how many in favor of passing this, or for this party? How many of you are for this party? And usually nowadays, our court is divided along ideology, unfortunately, even though that's not the way it's supposed to be. And we have 5 conservative judges and 4 somewhat liberal judges. So say a court is a 5-4 vote, then whoever's in the majority will write the majority opinion. You need to know what a majority opinion is. Usually it might be written by the Chief Justice, or the Chief Justice will assign that job to somebody to write that. And basically they're saying, we rule because these are the reasons why we rule in favor of this person or situation. A concurring opinion is offered by a justice so for example, if you have 5 people that are for it, and whoever wrote the majority opinion didn't include certain things that one of the other justices that voted for it wanted to write. Maybe it's something a little bit different or something they want to say. They'll write a concurring opinion. I also agree. However, there's a different reason why I agree, and this wasn't mentioned in this opinion. And then you have the 4 that lost, assuming it's a 5-4 vote. Those are the dissenters. Then you usually have one person that writes a dissenting opinion, but they could all write an opinion. Usually they don't. They have a majority opinion and a dissenting opinion explaining why they voted against it. Sometimes you may have 2 or 3 on each side. But really only the majority opinion has the binding power of law. So this basically says, this is our decision. This is why, here on out, we have the last say. But it's good to have dissenting opinions written out and why they think it's a problem, because you might get a different court years down the line that will look at the dissenting opinion and say, yeah, they were right, they were wrong. So, and then they can overturn it. All right. Supreme Court has clerks. This is a highly highly sought after position for recent law school graduates. They try to get a job. It's 2 years long. They help the justices write the opinions, choose the cases, do all the research. It's a tiring job, and most of the time it's people who don't have families, lives, or any other jobs because they have to do a lot of reading as well. So if you like to read and you like the law, this could be a career for you. And then we also have the confirmation battles. Many of you probably remember last year, or maybe it was this year still. It seems, I think it was this year. The battle of confirming Brett Kavanaugh. So you have, it can become very political, and confirmation hearings often are partisan debates, which is not really what the court's supposed to be about. But the Senate Judiciary Committee holds hearings and then makes a recommendation to the full Senate. So we saw the publicized hearings about Brett Kavanaugh on TV. If you didn't hear about that, then you haven't been paying attention to the news, but he's now our new confirmed ninth justice that took over for Justice Kennedy, who decided to retire. So the only time there's openings in the court is when someone retires, dies, or has to leave because of sickness or whatever. So this is an old one. So Antonin Scalia has died. So we have Gorsuch, I believe, is in his place. And Sandra Day O'Connor, she retired, and she was replaced by Elaine. Oh dear. The other. So we have two female justices. Okay, I'm gonna have to get back to you on their two names. This is an old chart. All right, so this chart shows the percentage of cases that they cases on free speech and how they ruled, and the red marks are if they ruled on a more conservative view, and the blue is if they ruled more liberally. So we're able to kind of tell a judge's leanings by the way they've ruled. So the role of law, in theory, is that justices decide on cases on legal facts. That they abide by precedent, so they look back at the other end that are set in previous cases, and that they're deciding cases on the basis of previous rulings and precedents. That's stare decisis. However, unfortunately, what often happens is that we have judges that use their ideology and partisanship, and their beliefs may be a powerful predictor of their vote. And whether they're a pragmatist or an originalist, like we discussed in our first chapter, if they look at the Constitution as a living, changing document, or if they interpret the document text literally. Sotomayor, and Kagan, those are the two judges. I knew they would come to me. And then now we have Kavanaugh. So we have 4 liberal judges: Ginsburg, 3 women, and Breyer. And then Kavanaugh is very conservative, so he joins Roberts, Thomas, Alito, and Gorsuch. And the swing vote was Kennedy, but Kennedy retired. So now it's pretty much 5 conservatives and 4 liberals. Okay, so now I'm not going to go into detail too much about these court cases. The first one we talked about, Marbury versus Madison. These are the 19 cases in your book that you need to pick a few to study and be able to write about in your final essay questions. McCullough versus Maryland was about a bank in Maryland, a federal bank that was built, and the state of Maryland wanted to tax the bank, and the bank, this guy McCullough, who was from the federal bank, sued them and said, "Hey, you can't tax us because we're the federal government." And they said, "Oh, yes, we can, because it doesn't say anything in the Constitution that you can make a bank." And McCullough, or the federal government, came back and said, "Oh, yes, it does. The necessary and proper clause allows us to do something that is necessary and proper, and we think that the United States needs a bank as we get bigger." So that's an interesting case there. Um, this one talks about contract definitions. The Dred Scott and Sanford. This was uh, before the Civil War, so before the abolition of slavery. A slave went to a free state, thought he was free, then they brought him back to a slave state. This ruling, if you read the wording, just the short couple paragraphs in your book, you may be really appalled. This is considered to be one of the worst decisions the Supreme Court ever made, especially the wording in it. So, yeah. All right. And then Plessy v. Ferguson, a lot of you referred to this in your definition on the first final. This was the case of a man who bought a ticket and decided to sit in a first class car in Louisiana, and this train still had segregated cars. And he said, "Hey, Civil War's passed. We have, the 14th Amendment. I'm supposed to have equal rights." And they said, "Oh yeah, well, you have a separate car, so it's separate but equal." So that's considered equal. So this court ruling basically said that you could have separate but equal facilities, and that's where the beginning of a lot of the Jim Crow laws started. And this was overturned with Brown v. Board of Education. They basically said, hey, separate is not equal. It's inherently not equal, and it's not constitutional. Let's see what some of the other ones. We have things on workers' rights, women's rights. This one restricted women that they could only work a certain amount of time because they had to stay home and take care of their children and fix the house up. If any of you women want to pick this one's kind of a interesting eyebrow raiser. This one talks about freedom of speech, workers' rights. Korematsu, it was about Japanese being brought into internment camps, and this is kind of an interesting read. They basically, at the time, the court said, "Oh no, we have the right to take away your civil liberties because there's a compelling interest." But they found out that actually years later there was no compelling government interest. There was the military had done some research, and there was no reason for them to believe that the Japanese Americans were dangerous or spies. So there was some compensation given years later to some of the elderly people that were still alive that had fought this issue in court. Then we have Brown v. Board of Education, Mapp v. Ohio. This is where they talked about the exclusionary rule when they had illegal, improper search and seizure without a warrant, and that you couldn't bring information into the court that wasn't obtained by a proper search warrant. Let's see. This is about the religious establishment clause. Roe v. Wade, about our right to privacy. U.S. versus Nixon. Nixon tried to use executive privilege in order not to give information when he was being impeached or about to be impeached. And the court basically said, no, you can't use executive privilege when it comes to a crime. You can't say that it's national security when you're covering up a crime. Then we have Bush v. Gore. This was a political question that the Supreme Court ruled on, which who knows what the outcome if they had continued the recount in Florida. That's an interesting one. And then this one is about the Affordable Care Act, or what's known as Obamacare, and about 2 issues in it. So this is a very interesting one to read as well. These 19 cases show the power of the court, how they were able to decide on a president, decide on workers' rights, decide on whether a woman has a right to choose an abortion or not. Those are powerful issues. Decide on whether a person gets to have equal access to everyone else just based on their color. These are all really important issues that originally the court wasn't set up to be the one to make those decisions. So the court has a lot of influence, and a lot of these cases are very controversial. So for your final, I would like you to, let's see if I can get this up here, make it clear. For one of your short essay on your final, I want you to write about 2 of those 19 landmark cases discussed in your text and lecture. Now, no need to go out and do extra research on Google because you've got the 19 cases there in your book. So be prepared to explain the same 3 things I asked you about Brown v. Board of Education. What was the case about? But you have to include the name. You can't get the name wrong because I'm only asking you to remember 2. How did the court rule, and why was it important? So I'm giving you all a choice of 6 to look at. 6 different ones, depending on what your last name begins with. Because I don't want you all to write, well, first of all, nobody's going to write on Brown v. Board of Education because it was already on your last exam. So it's really only 18 that you can choose from. So if your last name begins with an A, B, C, D, E, then please look at cases 1, 3, 5, 14, 16, and 19. Pick 2 of these and be able to write on this in clear sentences, not a list, like most of you did, in clear, in a paragraph or 2, answering these questions, or 3. No more than 3, though. And if your last name begins with an F, and then H, I, J, K, A, B, C, D, E, F, G, H, I, J, K, L, M, please do court case number 2, 4, 6, 8, 10, or 18. And if your last name is N through Z, 7, 8, 11, 13, 15. I tried to spread them out so you had some old cases and some new cases. So please write on 2 of the 3 cases, whatever your name falls under. So I hope everybody understands that. And then the criticisms of the court is that the cost of court litigation, sometimes the legal system has a bias, the power of the legal system and the corruption of lawyers. Some ideas for reform is that a decline in judges' payments might affect the ability to attract good judges. They have a smaller budget, so maybe raising their pay. Another thing is giving them term limits, which might address the idea of unelected judges. So you could move a Supreme Court judge to an appellate court, so they still have a job, or the other thing, another one is to give them term limits, but that are long enough. I think I heard one suggestion: make their term limits like 18 years. That's a good career. They don't have to worry about, how they're going to. And then every 2 years, a new judge would be up for re-election or reappointing, and then it would be automatic that president could appoint a new judge. Because what we saw with Obama was Scalia died. He found a new appointee, but the Senate at the time was Republican majority, and they refused for a year and a half to even consider their judge, and waited until the election when Trump got into office, and then they picked their type of judge. But if you change the rules to where you just say every 2 years a president gets to elect, so every presidential term they get to select 2 different judges, so you're always having a rotation of the bench, is another idea. And then maybe modify court precedents that give Congress the authority to modify court precedents and share power, give Congress the authority to share power of interpreting the Constitution. Okay, so lastly, the court system. This is a funny video you can watch. It's also John Oliver. It's more funny than educational, but gotta have fun. So I didn't do an exam notes at the end here, but everything that was in bold you'll probably see on the exam, plus that essay question. So please refer to the notes, and have a great day. We have just a few more left, and I'll talk to you on the next lecture.